In 2003, a man in Tulsa, Oklahoma entered a local clothing store to pick up a few items. He found some clothing that he liked and decided to take them. In other words, he wanted to steal them. But he also noticed that there were security tags attached to the items he wanted. He knew that if he walked past the electronic sensor near the exit, it would trigger the alarm. So he figured he would outsmart the system by first removing the tags. Once all the tags were off the items, he attempted to leave the store with his new wardrobe. But to his surprise, after all that effort, the electronic sensor still set off the alarm as he was leaving. He was then detained by store security until police arrived. Just imagine the look on his face. So what happened? Well, even though he removed the security tags, what he did with the tags was really dumb. He had placed them in his pocket, which makes no sense. That has the same effect as leaving them on. Perhaps he thought they only trigger the alarm if they are attached to the clothing. Then again, maybe he wanted to steal the tags as well. At any rate, he was arrested and charged with theft. In 2013, Priscilla Pena and Michelle Blassingale arrived at John F. Kennedy Airport in New York. They had just come off a JetBlue flight from the Dominican Republic. No doubt they were feeling good at this point. They had finally arrived at their destination and were ready to exit with their luggage and return home to the Bronx. However, a drug-sniffing dog alerted customs agents to something strange around Pena's midsection. This prompted agents to search her luggage. During these types of searches, it is common for law enforcement to observe the reaction of a suspect. And that's exactly what happened in this instance. As agents searched through Pena's baggage, they noticed that she appeared very nervous. An agent then requested a pat-down and Pena agreed. Perhaps she was confident they wouldn't find anything on her person. However, during the pat-down, they noticed a hard object around her stomach and buttocks area. They also knew that the firm stomach and butt wasn't due to her working out. Obviously, there was something else going on. Agents then performed a partial strip search. That's when they discovered that she was wearing a strange diaper. But unlike the normal adult diapers similar to Depends, this one turned out to be homemade. And it was worn for a different reason. She had stuffed the fake diaper with packets of cocaine. Pena was then placed under arrest. She also told agents she was traveling with Blassingale. Agents then searched the other woman and found another homemade diaper packed with cocaine. According to customs agents, the two women were allegedly found with nearly 7 kilos of cocaine each. You might be wondering why anyone would take such a risk knowing you had to get through all that security. Well, amazingly, the percentage of smugglers getting caught is estimated to be quite low when compared to the ones who get through. So the odds are pretty good for potential smugglers, which is also evident from the amount of drugs flowing in the country. As for these two women, they were arrested and their bond was set at $150,000. This next story is not so much a crime, but rather a story about liability. Craig and Kerry Melchiorin of Australia had 2 daughters. The first was born in 1985 and the second in 1988. By 1991, they decided not to have any more children. So in 1992, Kerry had tubal ligation, or what is commonly known as having one's tubes tied. She was 40 years old at the time. The procedure was performed at Brisbane's Redland Hospital by a Dr. Stephen Katanak. After the procedure, the couple was able to plan their future and finances based on a family of 4. However, in late 1996, at the age of 44, Mrs. Melchior received some shocking news. She discovered that she was pregnant again. In 1997, she gave birth to their 3rd child, a boy called Jordan. This was just 5 years after having her tubes tied. Obviously, this isn't how tubal ligation should work. So what went wrong? Well, according to reports, Mrs. Melchior told Dr. Katanak that when she was 15 she had an appendix operation. She informed him that her right ovary and right fallopian tube had been removed during the surgery. So based on that information, Dr. Katanak performed the tubal ligation only on the left fallopian tube. But here's the problem. Mrs. Melchior was wrong. Her right ovary and fallopian tube were never removed. And since Dr. Katanak went on her flawed information, he never looked on her right side. That meant that the procedure he performed was not complete and she could still get pregnant. The couple took legal action against the doctor and the state of Queensland for the pain, suffering, and costs associated with the pregnancy, the birth, and raising the boy. The case went to Australia's High Court for a decision on whether the costs of child raising were connected to the doctor's negligence. In a surprise 4-3 decision, the judges ruled in the family's favor. They then awarded the couple over $100,000 in damages. They reasoned that the costs of raising the boy were directly linked to the negligence of the doctor who performed the tubal ligation. The trial judge found Dr. Katanak had been negligent in accepting his patient's claim that her right fallopian tube had been removed. They felt he should have warned her that if she was wrong, there was a risk of pregnancy. The court determined that not awarding costs for child support would be neither proper compensation for the family nor a sufficient civil sanction to discourage negligence among doctors. The couple's lawyer argued that the Melchiors loved their son, but that didn't put food on the table or a shirt on his back. He said this is why they had now been compensated. Of course, the medical community raised concern that this could lead to other parents claiming they were victims of botched contraceptive procedures. And this would result in higher insurance costs for doctors. In its final judgment, the Queensland Supreme Court considered 3 separate claims. They awarded Mrs. Melchior over $103,000 in damages related to the pregnancy and birth. This would include loss of some part-time employment earnings, loss of capacity to take up further employment, and other damages. In the second claim, Mr. Melchior was awarded $3,000 for loss of consortium. Loss of consortium is a type of personal injury claim typically brought by the spouse or close relative of a victim. The relative sues the person who caused the harm because the person injured can no longer provide the same affection, companionship, comfort, or sexual relations. As for the third claim, the court considered what it would cost Mr. Melchior for housing, clothing, feeding, educating and entertaining the child up to age 18. The family was awarded over $105,000 for this third claim. In 2003, the Court of Appeal dismissed the appeal by Dr. Katanak and the state of Queensland. Thus, the judgment for the 3 claims filed by the Melchiors stood as a final decision. Clearly, the family made out quite well, and if they invested that money, they probably did even better. But because of this case, new legislation and reforms were written by Australian state governments. The goal was to prevent courts from awarding damages for what amounts to nothing more than the normal costs associated with raising a child.